a change so that this incident will not reoccur next time, please. I'm so sorry about that.
We thank God.
The next one is the members, the message the errand you sent me to accomplish will be communicated to you later. Gentlemen, you mention your order in order of seniority.
My Lord the Chairman, distinguished members of this panel, may I respectfully indicate my interest in number 3 on the list.
Colleagues,
Petition number JPI Anambra State 19, 2020. Petition by Chief Bonaventure Mokwe against the unlawful detention, torture, attempted murder framework by Special Anti-Robbery Squad, Nigerian Police Force, Anambra State Police Command. My Lord, the petitioner is present, represented by counsel.
Registrar, approach the bench, please.
M.O.
O.
Ilo Isuki appears with me for the petition.
Yes?
May it please this honorable panel my name is Alex HSM, Senior Advocate of Nigeria. But I respectfully appear for Mr. Peter Obi, who incidentally is an applicant in these proceedings. I appear respectfully with my colleagues, Messrs. Kaine Anawune, and Chindi Amankwe. Lord, we respectfully announce appearance for Mr. Chindi Amankwe. Lord Amankwe, yes, Chindi, CHINDU. With respect, then the Lord Amankwe is AMANKWE. With respect. Lord, I have
to be titled JP1, slash ANS slash 19M slash 2020. JPI slash ANS slash 19M, that's motion, slash 2020. For purposes of declaration, please.
as the
The main petition is 19, simplicity. Because we have exhibits attached.
Mr. Leather, you have two motions, sir. Are we referring to the first one or the second one? So sorry, sir. Sorry. There's a file two motion. Two. The court may want to distinguish. I think M1 and M2.
Lord, which one do you have, sir?
Thursday of November 2020.
They were all dated the same day. Beloved, can we identify them by the prayers on the face of the motion paper? Yes, sir. That is the second motion, sir. There is one for leave to be heard by way of. Lord, I think he has been.
JP1/ANS/19M1 2020 is the first one, right? The other one is 19M2.
Motion for leave is M1. Motion number 1. Motion for leave.
As God pleases. Lord, permit me respectfully to introduce my applications. Yes, sir. Lord, before then, Lord, I want to introduce the substratum of my application. Lord, my application is predicated on 3 principal cardinal. One, that the complaint of the complainant in JP1/ANS/1920 is a subject matter of a pending litigation at the Court of Appeal. Lord, I'm making a foundation. Oh, as copies.
And even the motion for leave. Prof, are you opposing? I'm opposed to the motion for
Both of them, sir.
motion for
Yes,
for
both
us
of
to
them.
hear him.
Yes, sir.
But I saw your counter argument. I thought
Yes.
you could have just had his motion.
Sorry?
I thought maybe you could have just had his motion M2 and allow him to be heard. This is not a regular court.
Yes,
Because
it's
not
not
guided by so much technicalities. If someone wants to be heard in this panel, we are amenable to hearing everybody.
I was thinking the procedure for being heard is when the panel invites the person. And besides, there are facts deposed therein in his affidavit, which I felt there was a need to set the facts straight.
No,
That is why.
asking to be heard.
Yes, sir.
They don't even need too much facts
Yeah.
for us to hear them.
No.
When we ask them that we want to hear them, that's when we need to challenge their facts. They have 2 motions.
In
here.
coming
You don't have a lot of time.
for the
And we
leave.
have about 180 petitions. And we have 12 cities to get these things done with. So if a senior advocate comes and a professor comes, this one petition can take us the entire day. So, Prof, please, can we get to his motion challenging the competence of your own petition? Because we are going to hear him. We are going to hear him. What we want to hear is the motion challenging the competence of your petition. We want to get it done with. Do you understand? I don't understand what I'm trying to say. So if the senior advocate had known, there would have been no need for this motion to be had, for leave to be had.
Even though it's not on trial. It's not on trial.
That's what you say on this motion.
Yes.
That's what we look at when we come to this motion. to be
The
heard.
only respondent here I know is the police.
Yes,
Yes,
you know.
the sole respondent.
Yes.
He has no business being
And
here.
so let's get to that.
As couples.
Yes, sir.
Leave definitely must be granted.
As couples. Lord, may I then withdraw the application for leave so we can make progress?
Also, who intend to can
As couples. Beloved, in view of time, the application is one dated 23rd November
I
2020.
hope you are following us. Yes, we are not ignoring you.
Okay, follow you.
Lord, I seek respectfully to move in terms of the motion paper. This is the third.
I have to warn. You know, you are very competent with honorable Justice BNO.
Too much.
Sit down. You are very competent with my procedure in court. If you start talking, I will just be looking at you. When you finish talking, I'll take up my pen. That was why I kept quiet. So please, it is a judicial panel. But it's not a regular court. We don't have the time, please.
So, Prof, we record that you have no objection.
I'm not.
To be no objection.
Six in the name. An order of this panel dismissing the complaints of the complainant forthwith for being subjudice, and this panel lacking the necessary virus to entertain same. Alternatively, my Lord, an order striking out the conflict. Lord, we have 5 grounds have 5 grounds upon which the application is predicated. Lord, we have an affidavit of 8 paragraphs. We rely on all the averments as contained in the affidavit in support of this application. Lord, we have a written address.
We are not verbatim reporters.
Oh, so sorry, Lord. So sorry, Lord. Lord, we have a affidavit of 8 paragraphs. Lord, we have a written address. Dated the 23rd of November 2020. 23rd November 2020. Lord, we also have the written address dated 23rd of November 2020. I adopt said address as my argument in the main in urging my Lord and distinguished members of the panel most respectfully to grant this application. Lord, I do not intend to waste the precious time of this panel. Permit me, Lord, to go to the exhibits in support of my application. My Lord, Exhibit A. Exhibit A is the complaints of the complainant. Exhibit A is the complaints of the complainant. I refer, my Lord,
for the leave.
Yes.
The second one is for.
I want to know the particular one. So sorry. All of them were 5.
Is a number there 2. There's one. There's a number written there in 8. 2.
Okay, 2.
Yes.
And 1.
Yes, and 1. 1 is for the leave. The second one.
1 is for the leave.
Yes, to differentiate. So sorry.
to refer my Lord specifically to page 4 of Exhibit A. My Lord, with your kind permission, I read out the principal relief of the complainant. Said, adequate heavy compensation to the tune of 120 million naira for illegal arrest, detention.
That's Exhibit A attached to the main petition, right?
As the court pleases. That is so. Then we got. Yeah, my Lord, I made reference to it as Exhibit A. It wasn't attached to my motion, sir. Yes, I made reference to it as Exhibit A. Then, my Lord, this is the principal relief being sought before this honorable panel by the complainant. It is therefore my humble submission, sir, as Exhibit A, the principal relief.
Adequate heavy compensation.
Yes.
To the tune of 120 million, right?
That is so, sir.
Okay.
For.
Hold on.
Detention. Harassment. Torture. Intimidation. Humiliation. And attempted murder. By the disbanded Special Anti-Robbery Squad, SARS or COSO, Anambra State of Nigerian Police Force. This is the prayer the claimant wants this honorable tribunal to grant in his favor. It is therefore my humble submission, with the greatest respect, that this distinguished panel lacks the jurisdiction to entertain this complaint. It is therefore my humble submission, with the greatest respect, that this distinguished panel lacks the jurisdiction to entertain the complaint. Permit me, my Lord, with the greatest respect, to make reference to a suit filed by the complainant. Lord, that is the suit number Exhibit B2. The Lord, Exhibit B2. I'm now referring to Exhibit B2 to buttress suit number 0/249/2014. Exhibit B2, suit number 0/249/2014. 2014. Now the parties in that suit are one. Chief Bonaventure Mokwe, plaintiff. Chief Bonaventure Mokwe, plaintiff, who incidentally is the complainant before this panel. Below, the defendants in that suit are His Excellency Mr. Peter Obi, then 2, Mr. James Nwafo, CSP. Lord Mr. James Nwafo, CSP, was the then commander of the Special Anti-Robbery Squad, SAS of the Nigerian Police. Lord, let me quickly refer my Lord to the principal relief, in fact the sole relief, which the claimant in that suit is seeking before the Court of Appeal now. With their commission, I read, sir, say, wherefore, the plaintiff claims for, and against the defendant jointly, the total sum of 5 billion naira only. 5 billion naira only. General damages for unlawful arrests, false imprisonment, and malicious prosecution. Unlawful arrests, false imprisonment, and malicious prosecution. I also refer this panel to another exhibit. That is exhibit B1, which is a sister suit. Exhibit B1. Yes. B1, yes, sir. Yes, sir. The first one is suit number 0/249/2014. Then the one I'm referring to now is 0200/2014. There are two different suits. It's 200. The one you showed to me. Yes, sir. The one I'm referring to now is B1. Below, look at it here. B1. As conferences, we are so sorry, sir. My Lord, respectfully, in Exhibit B1, suit number 0/200/2014, the parties therein are Chief Bonaventure Mokwe, plaintiff. The defendants are the Governor of Anambra State, 2, the Attorney General and Commissioner for Justice, Anambra State. Permit me, my Lord, to refer you also to the reliefs being sought. My Lord, in this one, the claimant is claiming the sum of 3 billion naira as damages for the demolition of upper class hotel. Yes, please.
Progress.
As the corpus.
It is D1.
Yes, please.
Suit number 0/200/2014.
Yes.
Note the parties and relief sought.
As the corpus. Lord, we have Exhibit C1. Exhibit C1, which is the notice and grounds of appeal. Exhibit C1, which is the notice and grounds of appeal of the appellant, which incepted an appeal Exhibit C1 is the notice and grounds of appeal filed by the appellant hearing, appellant who is the claimant before this panel, before the Court of Appeal, Enugu Division, against the decision of the High Court of Anambra State. Lord, Exhibit C1 relates to suit number 0/200/2014. Exhibit C1 relates to suit number 0/200/2014. And then the Lord, Exhibit C2 Exhibit C2 is also a notice and grounds of appeal with respect to suit number 0249/2014. Also filed by the claimant, who is the appellant in that court. I therefore submit with the greatest respect that a community reading of the entire gamut of Exhibit A, which is the complaint of the complainant. I therefore submit that a community reading of the entire gamut of Exhibit A, which is the complaint of the complainant before this panel. Exhibit A. 19A, complaint 19A, yes sir. Yes. Vis-a-vis Exhibit B, B1, vis-a-vis Exhibit B, B1, C and C1. Attached to my application, grateful sir, which show that the substratum, the Rex of the complaint before this panel is a subject matter of pending litigations pending before courts of competent jurisdiction. My Lord, looking at the terms of engagement of this panel, I have carefully perused the subject matter of the complaint. Pending appeals and the Court of Appeal, two different pending appeals. Everything that has to do with the arrest by SARS, detention, torture, demolition of the purported upper class hotel, the losses suffered, they are all sub judice. In addition to this, it is also my submission that the terms of reference,
like I said,
yes.
we read
Thank you, sir.
everything you file.
Thank you, sir. Thank you, sir.
Unless you are just urging us on something that is not contained on the written address. But I know that this issue of sub-judice, this issue of this petition being sub-judice,
yes,
are well argued.
Thank you. Thank you, sir. I'm grateful, sir. My Lord, for clarity, let me also go to an issue and I take my seat. My Lord, I have to say this because we have media here And Lord, before now, there has been serious campaign of calumny, blackmail against my clients in the social media. And Lord, at the point I brought my application before this panel. Yes, sir.
Let me not cut you off. There is also against me.
As governor.
Yes.
Lord, I did that.
Please.
I did that.
Because I was reported, I haven't said something or many things I did never say.
Lord,
I was reported.
I did that as that.
And in my usual way, I don't even reply to such.
Lord, a final point. May I also refer this panel to page 2 of Exhibit A. Lord, starting from page 1 of Exhibit A. Paragraph 4. The complaint.
It's the petition, Exhibit, we label it, Exhibit E19.
Yes, sir. Lord, the petition Exhibit P19A. Lord, paragraph 4 of that complaint, and I read with the greatest respect. The governor said, the then governor, up to paragraph 5, where the complainant indicted the then governor.
Yes,
Yes, sir.
the processes are before me, please.
As governor.
We have read.
As governor.
Please, just in intent, please.
My Lord, I urge this panel most respectfully. I urge this panel most respectfully in the determination of this application to grant my prayers and to accordingly dismiss or strike out the complaint. Please, because I thank the Lord for the kind indulgence. Yes, sir. Beloved, I have an online copy. I have an online copy. As God blesses.
We also have units here.
Yes, sir.
So that
Yes. Beloved, I can't hear you.
I'm saying that since you said that you are conversant with our terms of reference,
Yes, sir.
that you can be rest assured
Yes, sir.
that we are going to stick to our terms of reference.
As God pleases. As God pleases. Lord, I have no doubt. I have seen the composition of the panel, and there are men and women of impeccable character. So I have no doubt. Thank you, my Lord.
We have no lady at the back. Right, approach the bench.
Well, in response to the application JPI ANS 19M2 2020, the petitioner caused to be filed a 9-paragraph affidavit the petitioner responded to that application will be placing heavy reliance on the content of the affidavit. Content as averred in the affidavit. Accompanying the affidavit is, counter affidavit, Accompanying the counter affidavit is a written address filed on the same day, side by side with the counter affidavit. We respectfully adopt the content of that written address as our submission on law. Respectfully, sirs, in adumberation, we respectfully submit that the application the application made by the has no leg to stand. The applicant, sir, with the greatest respect, is neither a victim of SARS nor the respondent in this matter. It has no leg to stand whatsoever. He is neither, His Excellency Mr. Kito, he is neither a victim of SARS nor the respondent in this matter. The sole respondent in this matter remains SARS, Nigerian Police Force. Any other person is a meddlesome interloper person. I don't want to use the word busybody, but they have no business in this matter. Sorry, sir. Sorry, sir.
That's not in the same language.
I'm so sorry. I withdraw the issue of busybody. It is meddlesome. I restricted to the word meddlesome. I have no business in this issue. The petitioner in this matter cannot recount his ordeal without mentioning how it went through. That is why his name was mentioned. He is in no way affected by, he will not be affected by the result, decision, or conclusion of this panel. It is the position of the petitioner that the application by the applicant be dismissed. Well, sir, furthermore, I place reliance on the exhibits relied upon by my little friend. I place reliance on them. Yes. They are there for your perusal, sir. Exhibit B1, Exhibit A, that is the petition itself. B1, B2.
You are placing reliance on exhibit what?
Exhibit A of
19A, please. Is it 19A or what?
19A. Okay. Our petition is 19A. I place reliance on that. They refer to it.
Are you referring to their own exhibits or what?
Yes, I first of all mentioned our petition, which they refer to, then their own exhibits. Their own exhibits. Exhibit B1, B2, C1, and C2. If the court looks at specifically, not community reading, specifically at exhibit B1, the parties there are Bonaventure Mokwe and Governor of Anambra State and Attorney General. Their exhibit B2 hasn't.
Hold on, you're also the court panel to look specifically
Yes.
parties in
B1, B2. Yes. If the court looks at B2, you see that which they relied heavily upon. The court will surmise that the applicant in this matter was sued in his personal capacity alongside Mr. James Mwafu. Personally, the police was never a respondent or defendant. The SARS was never a respondent. It remains good law, sir. It remains good law. In our jurisprudence, that I can decide to come after my defendants individually, and I will not be stopped until I get what I want. I have no prevention, I have no impediment. If I separate my defendants and bring many actions, it shall not stop as Sabbath is stopping whatsoever. My Lord, for emphasis, the panel is inquiry into SARS. SARS, not P2B, not James Waff. SARS of the Nigerian police. No personal capacity. If I decide to go outside the framework of my duties and do something, I can be sued as a person. It doesn't affect my official capacity. It is important to appreciate that. Thought fissures can be separated and sued when you get the other one until you get what you want. That is the present position of the law. But only the applicant made heavy weather of lack of jurisdiction. It doesn't exist. The panel is sufficiently empowered and has the necessary juries. Has the necessary juries being set up by Section 8 of the Commission of Inquiries Act. Commission of Inquiries Law. Cap 31. Laws of Anambra State. Looking at the rules of this panel made pursuant to Section 8, setting up. Sorry. Looking at Rule 1 of the rules made pursuant to Section 8. With leave of court, let me paraphrase just very shortly. Persons who may lodge grievance or complaints before the panel, a victim of SARS and other police abuse within Anambra State. Sorry. Yes, I want to conclude. Just a very short one before I conclude. I'm so sorry, sir. Just a very short one.
Professor,
I'm so sorry. Just one sentence. I just want to conclude. I just want to conclude, sir. Just a very short one. Yes. So,
why are you putting up here? Why are you putting up here? You cannot, please. He's addressing me. Let's go on.
Yes, sir. I just want to make a last minute issue. The Exhibit B1 is specifically on property. It is not before you. On the property, the demolition of the hotel. The relief speaks for itself. Exhibit B2 is against two persons in their personal capacity. Finally, the relief in our petition is for compensation. That's the final thing I'm saying.
Not in your written address.
No, this one is not. This is the final thing. I'm not going to say anything again. D2 is a suit against two persons in their personal capacity. Listen. In fact, B1 is specifically on the issue of demolition of the upper class of the. Yes, the relief sought in that petition is for compensation against SARS. Brutality. These are distinct issues. Compensation. Compensation, not damages. Compensation. The police. Listen. My Lord, for all that I have said, for all that I have said, my Lord, I pray the panel, distinguished members, to dismiss this application and allow us conclude our addendum before it, which was what today was rated for. I didn't want to disturb the proceedings. That's why I didn't want to raise an objection to his moving this application. To dismiss this application, I've been looking for where we have costs here, but I've not seen.
I will not even grant them.
May it please the court, sir.
Beloved distinguished panel, although we filed our response to the 19th, but I align myself with the submission of the legal counsel. Yes, sir. Yes, sir. I said although we filed our response to the substantive 19 day. We have looked at the documents availed us this morning, and I align myself with the submissions of the learned SAN, urging the Honorable Panel to grant the prayers as sought. I don't want to go into the substance of the application yet. So when the time comes. By way of applying points of law.
Brother, I have an issue with that, sir. I'm so sorry. I have an issue with that, sir. He has no response to my documents, even though we are not operating what the system is called. But he shouldn't be held on the plan points of law, sir. With very great respect. Sorry?
Let's hear you.
As publicists.
Thank you, my Lord. My Lord, let me start with the submission made by the learned professor of law to the effect that what they are seeking here is a compensation and not damages. I want to start from there. My Lord, for there to be a compensation in law there must be an indictment. Lord, for there to be a compensation in law, there must be an indictment. The law is right. For there to be a compensation in law, there must be an indictment which will necessitate the compensation. If this panel grants the reliefs of the complainant, yes, sir. If this honorable panel grants the complaints of the complainant, my Lord, two things will arise. One is that this panel must have acted against the spirit
Just sit down.
Thank you, sir.
Please, let's not stretch issues. Our terms of reference are: 1, to receive and investigate a complaint of police brutality relating to torture, high-handedness, and alleged extrajudicial killings by SARS and police in the state. 2, to evaluate evidence presented and other surrounding circumstances and draw conclusions as to the validity of the complaints. And in my own instance, I have underlined validity. 3, recommend compensation and other remedial measure where appropriate. And I have underlined where appropriate. 4, recommend compensation and other remedial measures where appropriate to the state. Where appropriate to the state. I have underlined where appropriate to the state. And I won't recommend anything that is not appropriate to the state. 5, to submit the report to the state government within 1 month. That is not viable.
My Lord, I understood the terms of reference of the panel. But my Lord, in our adversary jurisprudence, the professor had made some submissions which by law I'm entitled to respond to. That is actually why I want to respond to them. For the records. Yes, sir. Yes, sir. If the panel agrees that there is an indictment, that the man is entitled to compensation, what it means is that all the allegations as contained in his complaint have been proved to the satisfaction of the panel. Then, secondly, my own clients. Secondly, yes, sir. Yes, sir. Yes, if the panel grants him 120 million as compensation,
it means that every fact in his petition.
What it means is that he has established the complaint as contained in his complaint. Because that is the only way the panel can grant that.
I don't understand the content of the terms of reference.
You know what I do? I'm only responding to the submission by the claimant's counsel. I'm only telling the court not to countenance his submissions. That is all I'm trying to do, sir. Second implication, with respect to my own clients, to whom certain allegations, criminal and civil allegations, have been made in the complaint. So the panel will proceed to also have that as proved without deference to section 36(1)(a) of the Constitution of the Federal Republic, which entitles this panel to give a hearing before a determination is made with respect to his civil rights and obligations.
You're not asking us to give you a hearing. You're asking that we should dismiss this petition.
Yes, sir.
You're not saying, you've not come to ask to be heard, to state your own part of the story with respect to his petition, so that we will understand this. If what you are asking us now is for you to file and rebut the facts as it touches on your client, to be a different thing.
I cannot, with the greatest respect, I cannot do that, because that would be outside the terms of engagement. As the complaint is constituted, the complaint is not properly constituted, because the complaint itself veered outside the realm of terms by bringing in third parties who are neither police officers nor SAS operatives. My client is not a police officer. He never worked for SAS. Police is a federal agency. In the course of presenting his petition, he has brought in allegations against somebody who is not a member of the police force. And on that note, the panel can strike out the complaint. On this singular note.
So, well, let us see now. Yes. If all the petitions we are treating against SARS here, all of them were instigated by private individuals.
Yes.
From the fact of this petition.
Yes.
Most of them, let me not over-exaggerate, but most of the police excesses, acts of lawlessness are instigated by individuals. In Nigeria, police, hardly can you just see a policeman going to arrest someone without somebody telling him, arrest this person. No.
With greatest respect, honorable member, this is our business. Lord, I quite agree with you. If the complainant has tailored his complaint with respect to state government, P2B did not act in personnel. It was not an action taken by him in personnel. And the complainant will come here and every word he will mention his name. My Lord, that is not proper. That is not proper. If the complaint, Lord, I have the complaint before me. I have the complaint before me.
Excuse me.
I just have to direct.
No. Keep that first. No, if he had said the governor of Anambra State that, would you have been happy?
Sorry, sir.
If he had said the then governor of Anambra State,
Yes.
without mentioning name,
Yes, sir.
because in one of the processes it said the governor of Anambra State,
Yes.
no mention of name,
Yes, sir.
you would have been happier.
Yes, sir.
Good.
You know that in their petition, of which you got,
Yes.
you even exhibited a picture of where his property was being demolished,
Yes.
and that the governor, the incumbent governor as at then, was present.
Yes, sir.
Now, the point my confusion, which I want you to clear is, if we had, after hearing his petition, even without your comment,
Yes.
the law empowers us to even summon someone whose name is mentioned in such a petition to find out the role he played.
That person must be a SAS operative, sir.
Okay, if that is your view, you can take it.
Yes.
You can record it.
Yes.
So
No, that is with the greatest respect, that is my position, sir. That is my position, with the greatest respect. So, my Lord, if Lord, if 120 million is granted here, then in OT 249-2014, he will be granted 3 billion.
Hold on. The governor of Anambra State, Dr. William, has earmarked 200 million only. I better let it drop, get into every person's head. Only 200 million. So if you ask for 20 billion, trillion, we will not exceed 200 million.
As God pleases. Lord, the summary of all I'm saying is that because the substance of these complaints are already sub judice, Lord, for this panel to sit here yes, I'm going by the blind law. Yes, if 120 million is granted here, then the Court of Appeal will grant 3 billion. Then the other Court of Appeal, because there are 2 Court of Appeals, will grant him another 2 billion. Yes, sir. Yes. Over the same police brutality, torture, detention, and demolition of his hotel. Over the same complaint. Over the same complaint. It has nothing to do with the parties. What determines the jurisdiction of a court are the reliefs being sought. And a lot we find that the reliefs are the same. In fact, it amounts to contempt of court and abuse of court process for the complainant to come to this panel. Yes, sir. My Lord, the learned professor of law mentioned about issue estoppel. I didn't say that. He mentioned about issue. I didn't say issue estoppel. I said estoppel. Yes, my Lord, I want to answer to that. And I'll submit reply to the issue of estoppel, which I didn't mention. He introduced that. Who has copies? So let me leave that. My Lord, he also mentioned about court fees. No, as the court pleases. As the court pleases. My Lord, he mentioned about the law establishing this commission that is for victims of SARS. I submit to that extent, with the greatest respect, I submit to that extent that the law relates to victims of SARS brutality who have not taken any step in any court of competent jurisdiction. That the only victim of SARS who can approach this honorable panel are those ones that have not taken any step in any court of law with respect to the subject matter of SARS brutality. So, Lord, to that extent, because this complainant is already before courts of competent jurisdiction, he cannot be held to approach this panel. My Lord, on that note, I urge my Lord to grant my application. Very pleased to Lord.
Basically, your will communicate the ruling and everything to the parties. The learners say we will take the addendum because they already filed an addendum. everything. If the application succeeds, we strike everything. If it does not succeed, then
My Lord, in my application, I have a prayer which is praying, my Lord, to stay further hearing with respect to any further presentation by you pending determinations.
a panel. This is not a regular court. I won't adjourn to deliver my ruling and then continue, please. That will waste a lot of time.
As God.
Please.
As God.
We are taking everything together, please.
You are well known. You are involving a lot of election petitions. The people have stayed proceedings there. We have only 12 sittings. We are only allowed to sit 12 times to conclude more than almost 200 petitions.
Yes,
I hope you understand.
my Lord, I don't know if my Lord will give us a date for ruling.
Yes, give a date after he has adopted his last process. Everything together.
As God please. As God please. So, Lord, let me wait.
You want us as John so you can go while he goes on?
No, let me listen to the proceedings. Yes, that's actually why I'm here.
If you don't want to stay, I'll compel you to stay.
As God.
Yes, sir. Sequel to the leave obtained from this honorable panel, we cause to be filed on the 20th day of November. An addendum.
What is the
20th of November, 2020. Sorry, sir.
The letter is dated 20th November, covering letter, but the addendum itself is dated 18th of November.
No, it's the forwarding letter for the addendum.
No. The letter,
Yes.
forwarding letter is dated 20th November.
Yes.
But the addendum itself is dated, her own says 17th, my own says 18th, his own says 17th.
May we seek leave of the panel to make the adjustments? Do we need to amend the date of the letter because that is the forwarding letter, sir? Sorry?
Just the date of the
Yes, the date of the addendum is 18th of November. So if I can be allowed to make the correction and
we also cause to be the applicant also caused to be deposed a 7-paragraph verifying and validating affidavit. On the 18th of November 2020.
Petitioner wishes to adopt the content of the petition, the addendum, and verifying affidavits. I believe the petitioner has to be shown. Sorry? There's a verifying affidavit there. Okay, sorry. Annexures A, B, and C. Yes, a decision of the High Court. It's A. I took it that it belongs to the High Court judgment. I don't know. It was attached there as a. Unless you want to separate it. That's the receipt of payment of CTC. Unless the court otherwise directs. It was not even supposed to be added in the first place. Sorry, sir. Ask up, please. If the petitioner is showing the documents he may want to adopt. So.
What is this supposed to be? The second B. And
It's an obligation of the CLO, Civil Liberties Organization.
You see why the Leonard Senior Advocate is why they are here. And Leonard Senior Advocate, we maintain that the best approach to this is just asking that the petition will be struck out. You don't want to report. No, you don't want to file an affidavit in rebuttal to all the facts that concerns you.
Milord, if it is struck out, there won't be any basis.
What if we don't strike it out?
Well, Milord, if that happens, then we'll take it from there. That's why we are here. Yes. And in any event, they have not availed us with any copy
Of
what the honorable member.
I thought we applied.
No.
Okay, they are then.
Yes, we don't have it. Yes. We are making a serious submission and we're not taking it very lightly, sir.
We understand.
Yes, sir.
We are also
We know the options are available to us.
We know that we also empowered. So when the Honorable Chairman was quarreling about the press week, when the last time they came, we all got embarrassed.
Yes.
When we started reading in the media that we summoned people to appear here. We didn't make any such order.
Yes.
But his name has been severally mentioned in this petition.
For a matter which is before a court of competent jurisdiction. Yes, sir.
We understand
Yes,
the
sir.
aspect of the matter being
Sub
we
judice.
understand it.
Yes, sir.
But we also understand the fact that we have been given a mandate to look into complaints, of police brutality and related matters.
Yes.
To look into the if somebody comes here and tells us that police has done this and done this to you, we are going to listen to the person. Somebody came and said the army, we say we cannot listen. Somebody came and said he has taken police to court and gotten remedies and struck out his petition. But this person is complaining about police as an institution, brutality and torture and all whatnot. And you are saying that we should not investigate it, we should just strike it out because somebody's name was mentioned.
That is not the only ground. There are 4 grounds. It is an abuse of process.
I understand.
Secondly,
we saw your ground.
Yes, secondly, it is sub judice. I cannot imagine that this panel can meddle with the matter which is in court.
No, that's what we told you now. I just said now that we had already struck out a petition which we found out on our own is before the Court of Appeal. But they are not on all fours. I can assure you. I don't want to preempt whatever is going to be the ruling of the panel on your application. But I think that it will be to the best interest of your client that he puts in a word, a response. Now that he has known what is being said about him, we are not concerned. To tell you the truth, we are not going to concern ourselves with anything that is said about him. we are going to strictly concern ourselves with what is said against police. That's what we are going to concern ourselves with, assuming that your application does not succeed. Assuming that your application does not succeed, we are not going to look twice at anywhere that his name is mentioned. But I think that having been a governor of this state, that a lot of people hold at a very high esteem. If some of these things are said about him and he doesn't say anything to the contrary through anybody, I don't think that
because my client is a fine gentleman, we have resisted the attempt of going to the social media to discuss events happening here. But my Lord, I have taken the hint. I have taken the hint. We shall await the outcome of the ruling, and when we see the outcome of the ruling, we shall review it and take the necessary actions. Yes, sir.
So, will you make a copy available today?
I'll take steps to do that. And additionally, there is
If it's in the judgment, don't touch it.
no, it's not in the judgment. But I referenced a lawyer in the addendum, but I didn't get the name correct. It should be Manuel Udebunam, sorry, sir. Manuel Udebunam. And then there's another omission.
Where is correct and sign. With a date.
The date.
Any of them?
Don't confuse. Do this one.
Each days by the side.
There's another omission.
Please, if you know you don't have any mask, get out of this hall.
Yes,
And I'll mark you absent.
Where's the mic? There's another.
what page? Give me microphone.
My Lord, I apologize immensely for my temperament, and I seriously apologize, but it has all to do with the predicament I found myself all these years, so it kind of boils off sometimes. But there's just something that happened here that will help my Lord to fully understand where my anger is coming from. This lawyer that is representing P2P.
I'm so sorry. I'm so sorry. No.
0/863M 2013 of 18th December 2013 by CN Bonaventure is hereby admitted and marked as the P19N. Publication by Civil Liberties Organization, CLO, undated, captioned Romancing Violence. Only God knows what that means. XBP 19.0. Internet printout captioned Where Are the Bodies? Admitted and marked XBP 19P. And finally, the verified affidavit of facts, sworn to on the 18th day of November 2020, is admitted and marked XBP 19Q. Thank you.
Prof, that's all. That's all for him.
Mr. Obi, are you filing any response to that? Okay, good. Gave us only 2 copies. Did you serve your learned friend with that before?
I have no time to make extra copies of the next.
You have to. You have to. You must adjourn. Others must have a bite.
Sorry. I say his response is bulky and he hasn't made enough copies.
Don't even know if I did anything.
So we have to adjourn.
You read any? You haven't read it.
We are thinking we could just conclude it today and then deal with the rulings and engage in the next. Now, we know that something like this will come. Let's see.
I don't know, sir. Who fired you?
The police.
Oh, the police.
They responded to the.
Yes, sir.
And you don't have a copy too.
No, I don't have a copy, sir. I don't have a copy.
So it's inevitable that we must adjourn it.
I can act for a stand down because I can act for a stand down.
We have 10 matters listed for today.
Yeah, but my lord, if this is disposed of, then others will have a few.
There's no way I can adjourn, stand down and then write the ruling and deliver. No, it's not possible, please.
I'll stop. Lord, as copies. Even though, my lord, the process filed by the police lawyer has nothing to do with my applications. It has nothing to do with my application.
Okay, so you don't feel that you want to look at it?
Well,
we are not in the petition.
Yes. My own application is quite distinct. Yes, sir.
Do you want to respond?
I've not even seen it. If I had seen it, at least if you had given me what copies this morning, I would have glossed through it for whatever it is worth. I have not even set eyes on it. You didn't even tell me if I had anything. You didn't even know it came for this case. I'm so sorry. didn't even tell me he came for this case. I don't know. And we'll be talking outside. He didn't tell me anything. What's happening? I don't know how to talk about this one.
That's what I'm saying.
Like one does not sign agreement in French.
That's what I'm saying. That it is inevitable.
Yes, it's inevitable, and I sympathize with what you are going through. It's not an easy task. So sorry.
Mr. B is hereby ordered to produce more copies of the response just filed this morning and serve the Petitioners' Council and make available more copies for the members of the panel. Petition is hereby adjourned for completion and final ruling on the application brought by SAN, the CMA Esquire, for Thursday, 10 December 2020. 10th, it's a Thursday.